May it please the Court, my name is Mariah Harani, and I am counsel for the respondent, Cynthia Boemio, who is now Cynthia Satius, and who was the appellee and the defendant at the courts below. The issue presented today about the AML guidelines has a lot of interesting and novel policy questions surrounding it, but the actual question before the Court today is a very narrow one, and that is whether the Court erroneously relied on the AML guidelines. And of course, it can hardly be said better than the Court of Special Appeals said it when it remarked that the argument that there was any reliance on the guidelines in this case was simply, quote, contrary to the record, unquote. And as has already been noted, the very fact of the trial court's express rejection of the outcome under the AML, as well as his statements that the number did not control its decision, I think, is very dispositive of the question of whether there can be any question that there was reliance here.
Well, to take the other point of view, I mean, one can hypothesize a situation where a judge says, and let me make it clear for the record, I am not relying on X. But yet there are other indications that, in fact, the judge, if it not being ultimately dispositive, it was certainly relevant to the judge's conclusion. What do we do? And I'm hearing the argument today, and in brief, that notwithstanding what the trial judge said here, he did use the guidelines, the AML guidelines, to some extent in coming to his ultimate findings.
Right.
So what's your reaction to that argument?
So that's a subsidiary question of, notwithstanding any issue of reliance, whether it was at all permissible.
Well, not really. I mean, yes, one could look at it that way, but one could also say that it goes directly to countermand the point that you're making, that he in fact did not rely, and that the Court of Special Appeals found he did not rely on the guidelines. I mean, if we look at Ms. Fate went to great effort to point out places in the record where there's at least a suggestion that it was relevant to his analysis. So let's assume we credit that. Then how does that bear on your point that he in fact did not rely upon the guidelines? What do you say to that?
Well, our position is that it was not inappropriate at all for him to consider the outcome under the guidelines. His consultation of the guidelines in and of itself was not error. And I think that we have case law in the statute that squarely and aptly addresses the issue of whether a judge can consider factors outside of the realm of the 12 enumerated ones. In fact, the statute seems to suggest that it's mandatory that a judge consider any factor that may bear on the fairness and reasonableness of an alimony award.
When the statute says factor, that's in the statute, isn't it?
Yes, it does say factor.
Does it mean facts pertinent to the circumstances of the parties rather than facts in the larger sense of what some organization has promulgated as appropriate guidelines?
I think that's unclear, but I do think that the policy that's undergirding the statute for a court that's sitting in its equitable capacity is that the court should consider whatever it deems relevant to assessing whether its award is ultimately objectively fair, which I think is what the court did in this case.
Am I correct, refresh my recollection, tell me if I'm wrong, that as counsel argued their cases to the court, neither relied upon or asked the court to consider the guidelines that the court had said he was aware of and would at least consult, although not authoritatively? I don't recall anybody getting up and saying, now, you really should do this because this is entirely consistent with these guidelines. Here's why you ought to decide it this way. Am I correct about that?
You are correct that it was at the judge's behest that those were considered.
Did anybody complain or object or squawk when the judge said early on in the process, you know, I've seen these guidelines, I'm somewhat familiar with them, what do you think of them? Did anybody say you can't use them?
Not that I know of.
All right.
Earlier, I asked about the judge's comment that he was giving sufficient alimony to allow the wife to have some savings because that had been the party's lifestyle. And petitioner's counsel responded that, well, yes, but he crossed out the line in her budget for contributions to a retirement plan. Is that correct?
Yes, it is correct that he took out the allowance in the financial statement, but I think you can make a distinction between what he was doing in terms of her retirement and the amount of money that he thought was appropriate in terms of the economic lifestyle of the parties, that they had a practice of living in a debt-free way for day-to-day needs, which is...
And is it legitimate to include savings under these circumstances? Or, as Ms. Fates said, no, the case that you're remembering, Judge, it was completely different circumstances.
Right. Well, if we're looking at unconscionably disparate standards of living,
right,
and you have one spouse who is able to fully provide for all of his needs and live at the standard of living of the marriage, and we have the other spouse who is scraping by and not able to provide for the incidentals and things that come up in the course of life because the budget has changed, then I think that's very relevant to the standards of living and the economic practices of the marriage. I mean, in fact, the debt-free lifestyle was the hallmark of this marriage, and it was something that the parties worked very hard to sustain. And then at the time of the divorce, you would have had a very significant change in lifestyles for that reason.
The question is, under our alimony statute, is it legitimate for a court to make an award in a sufficient amount to allow the recipient spouse to actually save?
Well, I think that the trial court is tasked with not only providing enough for support, but also to bridge the gap to make the unconscionable disparity less. And I think that that could be something that goes towards easing the unconscionable disparity in standards of living.
Do you think savings is an addition of unconscionability, or inability to save can be part of an unconscionability determination?
In standards of living, yes, I do.
Any cases to support that?
Not any directly on point. Continue. So I think, in conclusion, it's very evident here that we have a trial court, and it's 44 pages of opinion that exhaustively considered all of the factors, gave a thoughtful analysis, and we have an otherwise pristine exercise of discretion. And in fact, the amount did not come from nowhere. There was certainly a rigorous analysis of financial statements. There was application of discretion in terms of the amounts on that financial statement. And again, we had a judge who found that there would be an unconscionable disparity and had to give enough in addition to ease that unconscionable disparity. And I think that there's no identifiable fact that we see in the record that undermines any of those conclusions that this judge acted in accordance with the law and appropriately exercises discretion. And I think the only basis for reversal of the award that you've really heard today requires you to conclude that a trial court who specifically remarked that the AAML guidelines were used for informational purposes only, that they did not control the court's decision and that were not authoritative, didn't actually mean what he said, and that the record, which supports all of those statements, doesn't actually say what it does. And
but what does it mean when someone says informational only? What is informational to a court?
I think that means that he was not using it as evidence. He was merely looking at whether his conclusion was objectively consistent with the conclusions of other people who have considered similar policy considerations.
Kind of a reality check?
Yeah, I think so. I think that that was a way for him.
Before he invoked this testing mechanism of the AAML guidelines, had he announced a figure?
I don't
It looked, and I think this is part of where Ms. Page is coming from, is a number in the $3,000 orbit
Right.
was not articulated on the record until he said, well, under the AAML guidelines, it would be $3,800, and that's not right. It should be $3,000.
Well, he had actually
So
gone.
you didn't get from the statutory factor analysis to $3,000, at least in his explication of his mental process.
Right.
He got to $3,000 backing down from the application of the AAML guidelines by factoring in what he thought was appropriate.
Well, I think that he had gone through the analysis first, and then he said, looking at that, this is what the AAML says, but I disagree with that, and this is actually what I mean, the $3,000 figure is actually, from my understanding, pretty consistent with what was actually requested.
How much was on which was on her financial statement at that point?
I believe that it was in the 3,000 range that was being requested for Ellen.
Of what she would need total?
Well, she had it was
Or
above
after her earnings?
above 3,000. I think she had about a $1,700 deficiency after her earnings. But her needs were in the 3,000 range, is my recollection.
There are a number of ways that this decision might come out, and we needn't speculate about what they might be. But I'd like to hear your view on what would be the preferred, from your perspective, the preferred decision. It could conceivably be the judge didn't rely on it, end of story. Or it could be it may have been relevant to the judge's ultimate determination, and it's not a problem because the AAML guidelines are permissible for consideration. I mean, there are a number of ways a decision on these facts might conceivably go. What, from your end of things, I think we've heard what the other side's position is, shouldn't consider them in your process. What is your position?
Although I agree that the inquiry, I think, can necessarily end at there was no reliance in this case, and therefore we've answered the question, I do think that it would be certainly supported by case law to say that it is perfectly permissible for a judge sitting in his equitable capacity to consider guidelines, as long as they're not, relied upon to the exclusion of the statutory factors and don't supplant the independent exercise of judgment, because I think that's consonant with what the law is now. So I think that perhaps that would advance things if there were a decision.
So you disagree with, I think Ms. Fate's answer to one or more of the questions today was it's not permissible for a trial judge to use those guidelines in the mix of things. Maybe as a confirmatory reality check, I think I heard was one phrase.
Yes, I believe that the case law and the statute support that it clearly is permissible for a judge to look at things like guidelines. Yes. Okay.
That it?
That's it.
Thank you.
Thank you.
State.